The broadcast is now starting. All attendees are in listen-only mode.
From my accent, I am not broadcasting from the United Kingdom. I am talking to you from the United States. I'll give you a little bit of my background. I am a lawyer in the United States. I also hold 4 certifications in IT, including one of the most advanced in cybersecurity. I teach the GDPR courses at least once a month, quite often more often. And I also teach and implement and audit on ISO 27000. And in addition to that, I have written extensively about, I've written 3 books on law and economics, and practiced probably almost every area of compliance you can think of: tax, securities laws, corporate in the United States, etc. But none of that right now. This morning, we are going to talk about the GDPR, but of other things. Now, a little bit about our firm, IT Governance. Now, GRC, Governance Risk Management, is a one-stop shop, and these are all the wonderful things we do for various companies. So basically, we help companies comply with compliance and privacy laws worldwide. Now, today's discussion will involve a number of different things. It will involve an overview of the current regulatory landscape. Now, as a bonus, in case any of you haven't been noticing, there was a new law that was passed last Thursday on June 28th. The law was passed in California, and California, if it was a separate country, would be the 5th largest GNP in the world after Japan and Germany. So it also represents 20% of the US economy. And they passed a new law called the California Consumer Privacy Act of 2018, and it will go into effect in 18 months. Now, as I go on today, I will talk about some of the other areas where the new law is similar in many ways to the GDPR. Okay, this is what when I see this chart, when my classes, what I like to tell everybody is to point out one very, very important thing. Now, in the middle, you see something called a data controller. Now, the data controllers are, of course, the most important people under the GDPR. And the data controllers are defined as someone who processes data and determines the purposes and the means of doing that. As soon as you determine the purposes and the means of processing data, you are a controller. Now, as soon as you are a data controller, you have all sorts of duties to the people, to your data subjects. Now, please note, there are no arrows going between the data subject and the data processor. That is because all of the duties for complying with the GDPR basically rest with the data controller. Data processors are quite limited in their duties under the GDPR. So if you have a choice, the whole thing that you want to be is to be a data processor. Now, how do you do that? Well, we'll talk about that later, but the best way to do it is called, remember the ways to limit your risk, is one of the 4 ways of limiting risks is to transfer it. And in this case, you're not transferring by insurance, you're transferring by contract. Now, also, up at the top there, we see our various supervisory authorities. They used to be called data protection authorities, but under the new act, they're supervisory authorities, and up there, they're listed Information Commissioner's Office, that's the UK Supervisory Authority, also the ICO. If you're in France, of course, you have to work with CNIL, Commission Nationale Informatique et Libération, and in Italy, it's Garante, and of course, in other countries that they have other names. I believe that in Germany, there are 15. Now, in any court system, like in the United States, we have a higher court, and the purpose of the higher court, the European Data Protection Board, the purpose of that higher court is to make sure that everybody is doing the same thing. One of the main reasons why the GDPR was passed was because under the prior directive, the Data Protection Directive, various countries could sort of go their own way. And that is a problem for many countries, especially the United States, because you have all sorts of different laws in different countries. And we have to remember that laws are limited by borders. Data is not. Data, of course, can go anywhere, but laws can't. So the best way to make compliance or have a regulatory framework that deals with data is to try to make it as uniform as possible across all member states. And that is exactly what the GDPR does, and that is exactly what the United States law does not do. So there's a major problem for those of you who have to comply with both. Anyway, so as you know, there are three major areas that could get you into trouble in the GDPR. The first one are violations of principles. The second one is violation of rights. And the third is illegal transfers into mean, vicious countries like ours. Anyway, so your first job is to make sure that you can give your data subjects concise and transparent and in plain language and access to their rights. Now, what I like to tell my delegates when I teach this course, and this has more to do with law and economics than anything else, is you have to think of the GDPR not necessarily as a question of privacy. You don't necessarily think of the GDPR as a cybersecurity, although it is both of those things. The GDPR does control privacy. It does have things to do with cybersecurity, but it's far more important than that. What the GDPR does is that it basically codifies a data subject's property rights in their own data. Let's say, for example, we sign a contract and I let you have my car. Well, how can you use my car? Well, because you have a lawful basis. That is one of the rights that you have. Now, let's say access. Of course, if we rent the car in the contract, I may say I want to have access to the car. You can't use it forever, so you have to bring it back. You can't necessarily sell it to anybody else. So basically what we're doing is we're providing the data subjects, we're outlining specifically what rights the data subjects, property rights, have in their own data. Now, who has to do this? Well, the person who let's put it this way, is at a data subject, what I am doing is I am allowing you as a controller to use my information. But there are very specific restrictions on how and why and in what ways you can use my information. So your object, the controller's job, is to make sure I can do it. So you have to give me information. You have to tell me how you're going to use my data. If you rent my car, you're going to have to tell me, how long you're going to drive it. When are you going to bring back? You can bring back next Tuesday or a week after that. All right. So you have to tell people very specifically what you're going to do with their information. And that's what the information right is. Access. You have to tell me basically, I have a right to find out what you're doing with my stuff. So that's basically the access. What access do I have? Now, this is Article 15 of the GDPR. This is also reflected in the California Consumer Privacy Act. One of the main aspects of the California Consumer Privacy Act is the right to see your data. They have very specific statements about your right to go see your data. So it's slightly different from the GDPR. So if you're thinking, well, I live in the United States or someplace, I don't have to comply, you're wrong. Because in 18 months, you're going to have to comply with this anyway. Rectification. The point of one of the principles is that one of the 7 principles, lawful, legitimate, adequate, uh, accurate is accurate. Now, accuracy says, okay, I have a right as a data subject to make sure that the information you have on me is accurate. And if it's not accurate, I have to have some way of enforcing that. That's what rectification is. I have to have the right to have you rectify and make sure my information is correct. I don't know what happens in Europe, but if you've ever tried to change your credit report in the United States, which is just filled with inaccurate information, it's basically impossible. This is a very important right. Erasure. All right, this is something new, and the interesting thing, it also exists now for just the past week, but it won't come into effect for 18 months. Erasure, a very strong erasure provision in the California Consumer Privacy Act, the CPA, as they're calling it. Anyway, the point of erasure is under certain circumstances, you have a right under the GDPR to have your data erased. Now, the thing is about the first three rights there, information access rectification, are absolute. The last five, erasure, restrictions, objections, data portability, and ought to be informed automated decision ratings, are qualified. You don't automatically get erasure all the time. You don't automatically get objection. Usually these things pop up in cases where you are processing data unlawfully, or someone gave their consent. And remember, the Lord giveth, the Lord taketh away. So if data subjects giveth consent, the data subject can take away consent. And usually that's what triggers all the rest of these rights: erasures, restrictions, objections, portability. So the technical challenge is to make sure that revocation of consent can also trigger the possibility of utilizing these other rights, and that's a challenge for the controller. There also is a right to erasure under the California law, but it is less restrictive. So that one you're going to have to do if you do business probably in the United States. Now, it is possible you only might do business in some states, but probably not. If you're doing in the internet business, you're probably going to find somebody in California. Anyway, so those are the other ones. Restriction. Again, if you revoke consent or you're being unlawful, you can restrict processing, or if object to processing. This usually happens if someone is doing mass marketing, which is fine under the legitimacy provision, but it's frowned upon. The California privacy law actually requires you to have a big red button that if you press, you get out of any direct marketing and out of any sales. So it's not exactly a right, but it's pretty close. Okay, data portability it's usually generally pretty easy these days. It's the right to move your data around. You may get sick of one provider and want to move your data to someplace else. So you have to make sure that they can get the data. Now, that's what it is. The regulation applies to controllers, basically irrespective where the processing takes place. So mostly controllers. Processors have two jobs. Basically, processors have to protect the information, provide security, and they have to help their controllers provide these rights. So, for example, if the controller has a request, gets a revocation of consent and a request for erasure, then they contact the processors, say it's a cloud provider like AWS, and says, please, remove all the information on this particular individual that may be in your cloud. And that's where the processor's duty ends. But the controller is answerable to the data subject and to the supervisory authority. So they're the ones that have most of the liability. Okay. Now, these are all a list of all the rights, and we went over those in the past slide. And the point, again, I want to make clear is that the first three are absolute, the last five are not. The right of access and the right of erasure also exist or will exist when that statute starts in 18 months in California. Okay, Now, under the data controllers and processors are done, I believe it's under Chapter 3, it's 24, uh, basically through 28 of all the articles, and the big one is Article 24. Now, let's say, again, if you're a data controller, um, a legal basis for collecting the data. Oh, what's that? Well, the legal basis are the 6 legal bases that are found in Article 6. Of those, you probably can only use 3 or 4. The one is vital interest, and unless you're in the blood business or hospitals, you're probably not going to see that. And the other is public, unless you're working for the government, most of the other ones. So you have to have a legal basis for collecting data. It's like if you use my car, you can't, come and take it, or you'd be subject to grand theft auto. You have to have a contract. You have to have my consent. You have to have a legal basis for using my car. Now you have to remember, this is my data, or actually I'm not in the EU, so it's your data, and the data controllers are using it basically to make money, and they have to have a reason, a legal reason, to actually have that, to have that data. Okay, the data controllers also determine which personal data to collect. Remember, purposes and means, that's the trigger. The purpose, okay, again, the purpose of the data means, and the individuals who or what they collect, which is very broad. What personally identifiable information is in Europe is quite different from what it is in the United States. The Europeans are very broad about that, and the Americans so far have restricted it. Okay, whether to disclose data to whom, but to do that, you probably have to have a direct, if you decide to disclose data to somebody else, it's like, if you borrow my car, you can't give it to somebody else without my permission. So deciding who to disclose the data to will most likely require the consent. Under the American law, the California law, there's a big red button that says whether or not you can do that or not. However, the difference is under the GDPR, it's consent, and under the California law, it's opt out. Okay, whether the subject access and the rights apply, subject access almost invariably applies, but some of the other rights may not. Now, how long to retain the data? That's one of those principles. It's absolute. It's like you can't have my car forever. You can only use my car, for as long as the contract says you can use my car. Same with data. Just because I give you my data doesn't mean that, you get to keep it forever. Now, normally what that means is you get to keep the data for basically up to the level of the statute of limitations, which of course will vary according to jurisdictions. So for example, in most United States, a lot of the statute of limitations for contract would be 3 years. And so basically that's how long you get to keep the data. Now, this is what the controller has to do. The big thing is, remember, you borrowed my information and your job is to protect it. You don't want anybody to steal it. I mean, that was one of the things that I found offensive. I got a letter from Credit Karma, and Credit Karma said, your email had been breached. Well, that happened a long time ago, so I wasn't worried. What was interesting, it had been breached by 6 corporations, none of which I'd heard of. So not only did they get my data in some weird way, they lost it. So the main thing that the controller has to do is that if you collect other people's information, for whatever reason you do so, it is your job to protect that information while it is in your hands. One way you can do that, and the GDPR suggests that, Article 40 and one other, is that what they do is they have codes of conduct. And so controllers are supposed to adhere to codes of conduct. There's one little problem with codes of conduct: they don't exist. So that's probably going to be moving on down the line. So one of the things you should do is implement technical and organizational measures. And of course, at IT governance, since this is what we do, we encourage people to use the ISO standards. And I have swallowed the Kool-Aid on that. So I think, again, that's the best way to do it. I'll tell you why. Now, remember I talked about the processor, and remember the chart. There is no arrow between the data subject and the, there's no arrow between the data subject and the processor. They have to go through the controller. The processors don't, you know, act on subject access requests. You don't make, if you're a data subject, you don't ask the processor to give you your information. The processor helps the controller do that. Now, Article 28 basically says there's a legal contract. Now, if you want to see a good legal contract, of course, the EU has kindly provided one. It's called the Slalom Project, SLALOM, and it's like slalom at EU. I think that's the link. I can't remember it exactly. But that gives you it's basically designed to be a cloud contract. And there are two parts of it. One is an SLA, service level agreement, and the other is basically the legal agreement. Now, if you look at Appendix 5, it basically includes a lot of the stuff that processors are supposed to do. So you have to make sure that all this stuff is in there, like assisting the controller by appropriate technical or ensuring compliance with the obligations. So the processors will basically help you do this. And since I advise some of these large processors, I can tell you they already have wonderful modules that they would be happy to sell you, which will, do all these wonderful things. However, what you as controllers or processors have to do with this contract, it's vitally important because this tells you who has the responsibility for what. So it's very important for you to consider this contract, and to do so, you should seek the advice of a legal advisor. Definitely not me, because I'm licensed in Florida. Anyway, so you should have an EU legal advisor who can tell you these type of things. If you want to take a look at the template, go to the Slalom Project, and there's a beautiful template which helps you decide what goes into this contract. One of the most important things from my perspective in the United States is you have to have a reason for sending data out of the EU, specifically to the United States, which has adamantly sort of refused to cooperate because we have a very colorful politician in this country. Anyway, to make sure you comply with Article 44, it's probably a good idea in your contract to make sure you have the standard contract clauses if you intend to move data out of the country, and this is important to put in your agreement with your processor. Okay, Article 30, records of processing activities. When I first saw this article, I thought, oh my God, you got to keep records of every little, piece of information that flows through your system. And that the reality is not at all. Is basically what you have to do is you have to have information on the types of information you collect. The really basic heart of the GDPR is your data inventory. That is where it all happens. If you know what data you keep, what you do with it, where you send it, how long you keep it, do you sell it, can you give it back, all that type of stuff. What categories of information? Do you have, sort of what I call hot categories of information, like Article 9, which is healthcare data, sexual preference data, religion, ethnic, that type of stuff. That is Article 9. That needs to be processed specially. Criminal convictions will have to be processed specially. Now, the great thing about the GDPR, unlike a lot of American laws, is that GDPR is symmetrical. If you see the language repeating itself over and over and over again in the GDPR, and that's why it's important. For example, records of processing activity. Here, a description of the categories of the data subject. All right, if you have a description of the categories of data, if you have completed, and you have to, your Article 30, and note that up here, it's not the responsibility of the processor. Article 30 just says the controller, all right? The controller has to do that. Now, however, if you do this properly, and the supervisory authorities are there to help you, I got a great template from the British one, is once you have the categories of information, well then, if you get a breach, you're required to do what? Oh, you're required to report the categories of data subjects been breached. Well, how are you going to find that out? Well, the easiest way to find that out, um, is to look at your Article 30 records. So if you do one of these things, it helps you do a lot of the others. And the most important thing is to make sure your data inventory is up to date, and preferably you'll have a data map to find out what goes where, how, and so you can basically help. It's not only helps you with Article 30, it helps you when you have to comply with the breach reporting and say like Article 33. It helps you comply with which data subjects get which rights. And that all goes down to your data inventory. And so if you do one of these articles correctly, it helps you with the other ones. Okay, I spoke a little bit about this. The controller shall. Note again, we're talking about controllers, not talking about processors. These are the basic principles. Lawfully, again, if you use my stuff, you have to do it lawfully. Otherwise, it's criminal. Collect for a specific. You got to tell me what you're going to do with my stuff. Just don't take it. Tell me what you're going to do with it. Adequate. I mean, don't take stuff you don't need. All right, that's a problem, because if you take stuff you don't need, then you got to pay to store it, then you got to give it back, and then you got to think, well, where is it? And besides, it's a potential legal liability. So if you don't need it, don't collect it. Accurate. Make sure that your data subjects can keep it up to date. And the quick and dirty way to do that is let them do it. Have a portal on your website saying, a lot of companies already have this. This is your profile. These are the information that we have on you, and please make sure it's accurate. Retained only for as long as necessary. There's a company in the United States that stores documents. They have warehouses everywhere. They're called Iron Mountain. And out of the stuff that goes into all these warehouses, and they're constantly growing, only 10% ever goes out. So basically, all these companies are paying, millions of dollars to store information that they don't need anymore. So, and if I can get rid of it, let's say, as a lawyer, I always think, well, I'm going to sue you for this. Do you have that document? They say, oh no, we destroyed that years ago. And if you destroy it before you even know about a potential lawsuit, or if you destroy it after statute of limitations, then it can't be used in the lawsuit anymore. It reduces costs, it reduces your liability. It's just something, it's just good process. Now, the last one is probably the most important, and that is to maintain security. Why is that important? Well, for every company, data is no longer ancillary to your business. It is your business. I don't care what your business is. It could be selling widgets. It could be doing healthcare. It could even be doing consulting. It doesn't really matter. Information is always the heart of every business. So it behooves all of us to use our best efforts to maintain security on that data. Also, there are two major, what the cybersecurity people like to call attack vectors. The two major attack vectors under the GDPR are a possible data breach, or your access, your subject access requests, or the SARs. Why are these hot? Because these are the ways that the supervisory authorities will become interested in you. Only, to the best of my knowledge, only Austria and Germany have threatened to audit firms. Most other firms will be reactive. Now, what are they going to react to? A complaint. And so far, that there hadn't been an avalanche of complaints. The highest number of complaints in the first month of the GDPR has been in the UK, where the ICO has received 1,000 of them. In France, I believe it's 400, but I think there are other places like Belgium who have received 3. But if you have a complaint, then the local supervisory authority could come in and check out and see what else you're doing wrong. The same as if you have not maintained security. If you have weak cybersecurity, the supervisory authority may come in and take a look at your stuff. Now, that's also true under the California law. They do require you to maintain higher levels of security. That's also true of a number of sector laws in the United States for public companies. For example, the Securities and Exchange Commission requires you to keep adequate cybersecurity. If you're in finance, the New York Department of Financial Services requires certain levels of cybersecurity, and there are certain state laws like where I live near Boston, in state of Massachusetts has specifically the law it requires you to have certain cybersecurity. Okay, data breach responsibility. Now, again, this is different for controllers and processors. The processor sort of gets out pretty easy on this one. A data processor has to notify the controller without undue delay. They don't, in other words, as soon as you know about it, which of course, as we all know, maybe months after the penetration, you have to report that to the controller. This how and in what way you report these should also be considered as probably good practice. Consider that as part of your contract. Note that the data processor does not contact the supervisory authority. They do not contact the data set. All that data processor has to do is notify the data controller without undue delay. Now, if you do business in other countries, specifically the United States, unfortunately, you have data breaches and you do have reporting requirements. Unfortunately, there's 50 of them because rather than the federal government doing it, each state has passed its own. Alabama just flew in, and so each state has its own data reporting requirement. So that is a challenge. The point is, if you do get a data breach, you have to report. Okay, administrative fines. All right, that's probably why a lot of you are here, is because of the administrative fines, which are supposed to be proportionate and dissuasive. However, the fines are not the reason that you should get your acts together and make sure that you have the technical ability to comply with privacy and to give the data subjects their privacy rights. The real reason, as I always say, is these types of laws aren't going anywhere. Part of the problem from an economic standpoint is because of the prohibition of transfers outside the EU without adequacy under Article 44 means that there's a whole bunch of countries out there who are trying to become adequate. Why? Because if you are an exporting country, say South Korea, you have to, or let's say Brazil, you are exporting a lot of stuff and a lot of information back and forth to all the three large, like Asia, North America, or specifically the United States, and specifically the EU. Now, if only one of those trading blocks have these requirements, who are you going to comply with? You're going to go to the higher standard. So all of these countries, Korea just passed one, Qatar ate the GDPR whole. Japan is changing its law. There's some changes in Brazil. There's the law in Australia has been around since 1988, and they, I'm sure, are upgrading it. Canada is adequate. So all of these countries are imposing these various types of laws. Hopefully there will be some coordination among them, but that can't be guaranteed. So yes, the fines are large, and also it could be a lot larger in the United States because the California Attorney General can give you fines of $7,500 per incident. Now, exactly what that is, I don't really know at this point. However, if you multiply that by a few hundred, you can get a very, very large number. Anyway, so the point is that these laws are going around the world, and as we see from the number of people who are now worried about cybersecurity, this is part of your brand. So the reason you want to protect people's data and give them property rights in their data, like privacy and cybersecurity, is because they want it. It's going to be part of your brand. If you, like, for example, you saw Tim Cook immediately after the Facebook and Cambridge Analytical problems, he jumped on television and pointed and wagged the finger at Facebook and said, "Oh, at Apple, we don't do this." We protect our customers. Well, that's part of the brand. Okay, now for controllers data notification is notification without undue delay, but no longer, it cannot be any longer than 72 hours. Now, the 72-hour rule has shown up, guess where, in the California law. It also shows up in a number of other American laws. So the 72 hours is something you have to do. Now, you have to describe the nature of the breach, and you have to describe the nature of the breach. It's better that if you report something. Now, there's a whole list of categories under, I believe, Article 33 that state what you have to report to the supervisory authority. It's better to report anything, or at least a partial list, if within the 72 hours, because at least you reported something. Under certain circumstances, you may have to report to the data subjects themselves. But the 72-hour apparently now is becoming standardized because it showed up in the California law. Now, how do you get out of that? Well, under a lot of American laws and under the GDPR, the get out of regulation free card is if there is unlikely to be any problems to the rights and freedoms of your data subjects. Well, what does that mean? That means that you've encrypted the data, and hopefully that not only have you encrypted the data, but the key to encrypting the data did not get stolen with the data itself. So the object of the game is to make, if at all possible, is to make sure you utilize encryption as much as possible, because then in that case, if the data breach and if the key is not also stolen, then you have it's unlikely that there will be any risk to the rights and freedoms of your data subject, and so it may be unnecessary to report at all. There are other similar requirements, statements under many state laws as well. So this is basically another impetus to start to encrypt your data whenever you possibly can. At rest, in transit, whatever it's doing, just make sure you do it. Okay, data breach. You have to occasionally, if necessary, you may have to communicate to the data subjects themselves. It could be if there, for example, is a high risk to the rights and freedoms. Well, how do you know that? Well, I don't really know that. So there are some discussions in the guidelines that say that. Probably the best way to do it is when you report your data breach, which you have to the supervisory authority, they can compel you to report your data breaches the data breach to your data subject. So it might be a good idea when you report your data breach to the supervisory authority is ask them. You see, the supervisory authorities, one of their major duties, and if you look at the Article 84, what's interesting to me as a former tax lawyer is that there are 11 mitigating circumstances under Article 84 before they fine you. And so one of the jobs of the supervisory authority is to help protect data subjects. So they're not necessarily looking to fine you. They've said this, they will if you do it constantly, or if you like a lot of American firms, I don't want to name names, who are not cooperating with the GDPR, then they will fine you. But best thing to do to determine whether or not you're supposed to contact the data subject is when you report the thing, ask the supervisory authority, because they may force you to do so anyway. They say, look, this is what I've lost. These are the categories. This was like if you've lost like an email address and a phone number and a name, I doubt that would be a high risk. If you've lost, thousands of criminal convictions or health information, you probably need to talk to the data subjects. There are similar provisions under U.S. law, but it's usually based on a specific number, not something like whatever a high risk of rights. And of course, the high risk is not going to materialize if everything is encrypted. So if you didn't need it, that's another reason. Okay, instant response. You want to take appropriate technical and organizational measures. You have to be able to do these responses within 72 hours. That's very important. So the object of the game is to be able to, prepare for these instances, which of course are going to happen to everybody, you have to do it as much as possible and as much as possible in advance. Okay. Limitations and restrictions. If for remember, the whole point of a processor is to be sure that your contract's in place. This includes subcontract. The controller, the processor can't just contract out or subcontract some of the stuff without the controller's permission. This again is why that contract between the controller and processor is so crucial, because you can define exactly when these, who can do what. Now, I was just reading an article. Is that, as we all know, and if we're in cybersecurity at all, that amateurs hack technology and professionals hack people, and most of the money gets stolen basically because an employee or somebody else makes a mistake. So the object of the game is that make sure that everybody is trained properly. And now it's not only necessary to train people as to things in cybersecurity, which is part of compliance. It's also necessary to train people to what the GDPR is and how to react to it. So, for example, you have to make sure that people understand what personally identifiable information is. You have to tell people what they have to do when they get a subject access request. So when someone asks them, what information you have on me, and give it back. So if the quicker you do that, the better trained your people are, the quicker and happier they are to help the data subject, the less likely that you are going to have any problems with their complaints. Happy data subjects don't go whining to the supervisory authorities. So the better you train your people and the quicker they can react to their obligations under the GDPR, the better chance you have of avoiding any problems with the supervisory authority. So it's very important to make sure your people are trained, and it's not something you do every year. It's probably something you probably want to think about doing every quarter. Okay. There are various ways to do that. Here are some of them about how to implement training. My favorite one was that the nastiest one I've heard, but I think it's rather interesting, was before you could log on to your computer, you had to answer a cybersecurity or maybe a GDPR question correctly. And if you didn't answer it correctly, you couldn't log in. You'd have to call the help desk or something to get the answer. So that is gave a lot. That's one way of making sure that your employees have enormous incentive. The other way to do it is another good way to make sure training is not only to utilize these things, but the gamification of it. So there's one large firm. It's one of the largest proxy servers in the world, and they have a penguin, a stuffed penguin, and whoever has the stuffed penguin is definitely top of the heap. So there's enormous competition to do the thing properly to get that penguin. So that's the best way to make sure that your staff are aware of all their obligations under the GDPR and all their requirements under cybersecurity. Remember, the question is who's responsible for cybersecurity in a corporation, and the answer is everybody. Okay, Article 32. Article 32 basically sets out the requirements for security under the GDPR. Now, unlike American laws, which are sort of checklists, thou shalt have this, 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 and this, the GDPR is much nicer. It's flexible. All right. It says that all you have to do sure is you have to make sure you have confidentiality, integrity, and availability. The constant CIA of cybersecurity. And remember, availability is in there. So if you have a DDoS and reflected DDoS attack, you have a problem. Now, you have to implement regular testing. The whole point about Article 32, though, is that it is relative. The question is whether or not it's appropriate. So they look at expense, they look at the technology, they look at the type of information you have. Obviously, if you have sensitive information, you have to have better cybersecurity than someone who just, like a lot of my clients, just collect B2B. So they just have names, phone numbers, email addresses, and that doesn't require the same level of protection as something more sensitive. Okay. And to help all of you do the various types of things, these are the courses that the IT governance offers. We don't see, I personally teach the F, and we'll probably teach the 27,000 ones fairly soon. Eventually, I'm probably sure might do something on California when we get to that. But the problem is, also the whole point about the GDPR is that it's and any law is that as a lawyer, I don't know what a law says until a court tells me. So there are a lot of gray areas that need to be filled in, and we're going to see that filled in over time. But until we know more, it's better to do as much as we possibly can to go with higher standards of compliance, because if you're going to do business anywhere, this is going to be the new standard. Okay, these are other types of things we do. There's a gap assessment toolkit which you can use. My favorite is and the most important thing, I think, is the data flow audit, which is absolutely magnificent because it actually tells you what information you're getting, and it also helps with your other documentation requirements. Cyber resilience. Now, the whole point of the GDPR, you have to remember the GDPR only, as I understand, I believe only has, there's a document, Article 24 requires you to have a data protection policy. And so policy isn't mentioned, but the word documentation is. The word documentation is mentioned 22 times in the GDPR. I was reading in a case, not from Europe, it was from Singapore. And the Singapore case, it was their data protection authority, and they said they were going after a big IT firm. No, they were going after hairdressers and a moving company. And they basically said, look, unless you document what you're doing, we don't know, I don't see how, we don't know how you might be able to prove that you're doing it. Nurses have a statement. They said basically, if you don't document, if you didn't document it, you didn't do it. So the whole point of having frameworks like ISO 27000 or frameworks like the 22301, which is the business continuity management system, is to make sure that you have that documentation. In the United States, I'm not talking about the GDPR, I'm talking about the good old United States, under the healthcare regulations. You might have heard of HIPAA. The regulator over here, the people who investigate it, don't go in and want to see your firewall configurations. They don't want to talk to your CM people. They want to see your documents. So that's basically going to be the standard for compliance with these things. Anyway, we're going to have another, maybe Alan might be back and he can give you the DPIA and you can register for that. In the meantime, I'm going to open this up for questions and we will see if we have any. So hopefully if we have any questions, feel free to provide them right now. And if not, that's fine. We can all go off and do whatever we did. Let me see if I can see what that is. Oh, well, let me see that. Do we get a copy of this webinar video? I believe yes. Okay, does erasure only apply to marketing data? No. Yeah, erasure, if it applies. Okay, the question is, remember, all those rights are relative. So if you have that data and the lawful reason you have it is, like, say, like consent, and the revoked consent, then erasure applies unless you're within one of the other exceptions. But it's like I always get a card, the same question from all my clients. And the question is, if someone gives me a card at a trade show, is that personally identifiable information? Well, yes. Well, what legal basis do I have? Well, if it's consent, that's your legal basis, then erasure applies. If not, it doesn't. Now, however, erasure will probably apply for the California law, so it's probably a pretty good idea to have some sort of processes for erasure in your in some sort of process for erasure in all of your technical systems, because if the GDPR doesn't require it, other countries might. Let's see, what data can be shared with auditors and third parties? I would say that I mean, you would probably want to be able to share all your data with your lawyers and auditors. I think that would almost go without saying, is that because as your agents, in other words, as part of your privacy policy, I've seen the language quite often that we intend to share our data with our employees, and the employees are under confidentiality. And that is, of course, very true with your lawyers and auditors. Now, lawyers and auditors are, I believe, although I'm not totally sure, are that wonderful, you might remember the chart, they are called third parties. Now, what exactly a third party is I'm not exactly sure, but I think it's probably a lawyer or an auditor. So yes, you can share the data with them because they're probably, as their agents, they're probably an employee. And so if you want to, you can throw that in your privacy notices that we may share our data with a particular professional, and that would probably cover it. What is your opinion on indemnity clauses now added to 99% of the data protection contracts? No. Uh, yeah, I don't. I don't think an indemnity clause. I question whether or not. I'm sure that AWS. The reason why an indemnity clause might be important, and this is, I've been pondering this. I've researched it. I don't really know. Is the problem is that under the GDPR, unlike a lot of American laws, you have three ways. If you're a data subject, you have three ways to enforce your rights. The first way is you file a complaint with the supervisory authority, and basically you get the supervisory authority to enforce your rights. The second way is you don't like what the supervisory authority is doing. You go to a court and you force the supervisory authority to do that. The third way is you can sue people outright. Now, who do you sue? Well, as an American litigator, not that I did that, but basically the old strain is you sue everybody. And so, of course, you are going to sue the processor and the processor as well as the controller. And the question is, let's say, for example, in your most processors, I believe, would be probably cloud things. So from an economic standpoint, they would probably be deeper pockets. Now, I'm not sure. One of the economic reasons, are these enforceable? Well, I don't really think so, because I don't think that the supervisory authority, if they found a processor was, if the processor was deficient in their cybersecurity, would nail the controller. They just say, no, we're going to fine the processor, and at that point, there's no indemnity, basically, because the controller is not liable. Now, I would definitely understand that, like, let's say AWS would want to be able to claw back or indemnify something if the controller was liable for it. The problem is, and I think the reason why they put those clauses in there is because the probabilities are that the controllers are probably less solvent than the processors. So I think what's going to happen with these things is that the large processors, because they're jointly and severally liable, although they might not be specifically negligent, may end up footing the bill for a lot of the negligence of the controllers, because the controllers might be bankrupt, you can't find them, they might not have sufficient assets, you name it. But whether or not there's a big difference between whether or not you put something in a contract and whether or not you're actually going to enforce it, or whether actually someone's going to get any money out of it. So you have to look at it from that standpoint. Okay, our corporate email address is PII. Oh, well, no, because corporate email, like my email address is wgamble@itgovernance.com, and yes, that would be because IT governance is located in England, so it's a controller under the territorial scope of the GDPR. And even though I'm just an American, I'm still a data subject under the GDPR. Is my email address PII? Yes, it is. The next question is of course, you always have to go on to legal so what, which is so what, and because it's not hard to get anybody's email address, and the problem is it's not worth it. The other thing you have to notice about the dark web and notice about the sensitivity of your data is another question is whether the level you have to protect it is can your data be monetized? I mean, yes, a corporate address can be is PII, and it's your job to protect it. Is there a high risk to rights and freedoms of an individual if that gets stolen? Probably not, because it's basically hard to monetize it. Do you have to comply? Yes. I mean, you may get a pain in the ass former employee of some corporation saying, well, give me back all my email address. Well, fine. Yeah, it's something you have to do, but it's something you should be able to do anyway because you haven't collected a lot of information, so it should be easy to come up with that subject. Do you recommend any steps that organization can take to show GDPR compliance? There are no codes of conduct for GDPR compliance right now. The only thing available, you cannot certify to SOC 2 or SOC 3 or the American NIST 853. You can't certify to those. The only thing you can certify to is ISO 27000. So there is no such thing as GDPR compliance. There may be firms out there who will sell you certificates or something and saying, well, you're GDPR compliant. The reality is you're not. You can become far better in terms of cybersecurity. You can become far more by adopting a certification of ISO 27001. The real reason that we're doing all these things, remember, is it's really, yes, this has something to regulation, but the economic impetus for this will be, first of all, our customers who are be concerned about our brand, whether or not we're cyber secure. And the second biggie, which I'm saying, is the data supply chain. Is you share data not only with your customers, but also with your partners. And especially in B2B businesses, you're all constantly sharing different types of information. And, like the Target breach occurred because one of their contractors wasn't resilient enough. So the whole point of this is not necessarily just because the supervisory authority is going to scare you. You want to make sure because you have a digital supply chain. How big and exhaustive should a data protection policy be? No, they're not long. Remember, a policy is a high-level document, so most of them should be fairly short. Your procedures might be, more thing, but a data protection policy should be fairly short. I would say that 99% of the privacy policies, for example, in the United States, are just awful, and I don't even know why they're there. There are 17 states that require it, but they don't require that. And actually, a number of organizations in Europe have already apparently brought actions against American companies for their privacy policies. Are we meant to record consent? Yes. You betcha. On prospective customers, you don't have to have. No, it's not. Consent is. Doesn't have to be exactly granular. It depends what you're doing with them. The best lawful basis. Remember, there's 6 lawful bases. The best lawful basis is always going to be contract, because you can't take that away. None of the other rights click in. So the best time to get the in terms of contract. Sole trader and partnerships. I'm not quite sure what that question is. Is an identifier personal data if it has meaning only in my database and the database. No. In the United States, um, let's say in the United States, if the man on the street couldn't identify the individual from the information given, like, let's say they have an IPv4 address, then it's not personal information. In Europe, they go to the other extreme. If anybody can identify it back to an individual, then it's PII. There is a court case in Germany that held that a DHCP IPv4 address was personal information. Is an identifier my data? Okay, if you can identify it, you can always anonymize. The best thing to do is anonymize. The difference between anonymization and pseudo-anonymizations, anonymization is not reversible. Okay, if we have an agreement with a client to be a processor and the data we process for them is hosted at a contracted vendor, such as or an infrastructure, yeah, you're a contractor. If you don't determine the purposes and the means of holding information, then you are a processor. But again, you have to make them sure that your contracts are drafted properly and that you basically state specifically who is who, and that you are a processor, and that you don't determine the purposes and means, and you're going to state that. Let's see. Actually, it's 11 o'clock. I'm not quite sure how many other questions I've got, but unfortunately I have to terminate the process right now because basically it's timing up. Anyway, thank you very much for coming, and of course, if you have any other need for GDPR stuff or other stuff, then feel free for contact us for other types of cybersecurity needs. Anyway, that is all I have for this evening and for this day. Actually, it's afternoon where most of you are, and so I would encourage you to have a lovely rest of the day. All right, have a lovely day.